Hi, my name is David King and I'm a partner in the private client team here at Harrison Clark Rickaby's. I'm joined by Beth King-Smith, who is the partner and the head of the Disputed Wills, Trust and Estates team.
One of the things I think you're seeing, Dave, is where mum or dad maybe are becoming more frail and questions of dementia, whether it's gardeners or kindly neighbours sort of interfering. Are you seeing more of that type of thing?
Given the ability for people to put things like powers of attorney in place, and we are seeing a greater uptake in people that actually have powers of attorney in place, but where people are reliant on third parties that are just helping them on perhaps an ad hoc basis, yes, we're seeing a lot more instances, particularly after people have died, because that's when the information typically comes to light. Through the executors doing their research into things like reviewing bank statements to check for lifetime gifting and that sort of thing. So yes, we are seeing more instances of those sort of shock third parties that have been involved with someone's life, then having to look into and perhaps explain to families why certain payments might have been being made to certain people. But obviously, it doesn't necessarily flow that the payments that were being made under undue influence or circumstances that might lead them to be questioned. Individuals have to be assumed to have capacity unless it can be sort of shown otherwise, and if the individual's made what you might perceive to be a decision that you don't agree with, doesn't necessarily mean it was the wrong decision or a decision that they hadn't made with proper thought and capacity.
When people come to you to think about making a will, do you usually recommend that they have an LPA at that stage as well? What's the benefit? Perhaps you could talk about that.
Yeah, definitely. So I think obviously the will is only effective on death. In many respects, a power of attorney, given that it's you being able to choose who it is that you want to deal with your affairs in a worst case scenario whereby you've lost capacity, can often, because you're alive, provide more benefit to you. Whilst obviously through the will you're choosing to pass on your assets to the people that you want to benefit. I think the LPA should be viewed as that lifetime security to make sure that your assets are protected whilst you're alive and for those ultimate beneficiaries as well. I strongly advocate putting in place both types, so the property and financial affairs and the health and welfare power of attorney.
And can you choose different people for the finance one and the health and wellbeing one?
Yep, so if you don't want the same people to make financial decisions for you as you would medical related decisions, yes, you've got complete freedom to choose who it is you want to appoint.
And do clients often do that? Do they choose family members perhaps closer to them and then perhaps somebody a bit more with financial acumen for the finance one?
Everyone has different views over perhaps their children, their sort of friends, family members that they would want to appoint in that capacity as an attorney. The big point for me is just people being alive to the fact that husband and wife scenario, they jointly own their property. If they had only chosen to appoint each other as attorney for one another, that could leave them in a situation whereby if one of them has lost capacity, that they wouldn't be able to sell a jointly owned asset, because effectively one person can't sign for themselves and for the other in their capacity as an attorney. And we are seeing LPAs that have been drafted on that basis. So I think even if you put powers of attorney in place a number of years ago that you think are fine on paper, they may very well be, but are they going to give you the practical benefits that you need to help support you in a time where you have lost capacity and decisions need to be made?